Welcome to this lecture by ProLegalminds on broadcast reproduction rights, an essential aspect of intellectual property rights. This topic involves the exclusive control granted to broadcasting organizations over their broadcast signals, allowing them to authorize or prohibit rebroadcasting, recording, or reproduction. Let us look into definition and scope. Broadcast reproduction rights protect the broadcast signal itself, distinguishing them from copyright, which protects the content being broadcasted. These rights empower broadcasters to manage how their signals are used, preventing unauthorized parties from exploiting their broadcasts. For instance, if a television network's signal is unlawfully rebroadcasted by a cable operator, the network has the legal right to intervene. Similarly, a radio station can enforce its rights if its broadcast is recorded and sold without permission. Let us understand legal framework. In India, broadcast reproduction rights are established under the Copyright Act of 1957, specifically in Section 37. This section provides broadcasting organizations with exclusive rights, such as the ability to rebroadcast their signal, allow public access to their broadcasts, create sound or visual recordings, and control the reproduction of these recordings. Infringing these rights can lead to legal consequences. These rights are protected for 25 years from the year of the original broadcast, offering broadcasters ample time to safeguard their content. Let us understand real-world applications. These rights are crucial for television networks and radio stations, enabling them to protect their investments and control the use of their broadcasts. By ensuring that their content isn't exploited without authorization, broadcasters can maintain their revenue streams and market integrity. Consider these examples. 1. Unauthorized cable rebroadcasting. A television network may discover that a cable operator is illegally rebroadcasting its content. The network can enforce its rights to stop this infringement. 2. Illegal recording and distribution. A radio station may find that its broadcast has been recorded and sold without its permission. The station can take legal action to protect its rights and prevent further unauthorized distribution. Case laws and international perspective. Several landmark cases have reinforced the importance of broadcast reproduction rights in India. For instance, in Gramophone Cases of India Limited v. Mars, Recording Perfect Limited, 2000, the court ruled that unauthorized recording of broadcasts violates the broadcaster's rights. Similarly, in Doordarshan v. R.K. Productions, 1996, the court upheld Doordarshan's rights against unauthorized reproduction and distribution of its broadcasts. Internationally, broadcast reproduction rights are recognized under treaties such as the Rome Convention, 1961, the TRIPS Agreement, 1994, and the WIPO Performances and Phonograms Treaty, WPPT, 1996. These treaties ensure the protection of broadcast reproduction rights across borders, highlighting their global significance. In conclusion, broadcast reproduction rights are vital for protecting the interests of broadcasting organizations. By securing these rights, the law allows broadcasters to control the use of their signals, safeguarding their investments. Understanding and enforcing these rights is crucial for the continued growth and integrity of the broadcasting industry, both in India and internationally.